I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. This is compilation 192 that we are walking in on today, and we will be in 3 different judges' courtrooms. Before I give you the rundown on those judges, don't forget to like, comment, share, and subscribe. Know that commentary will be left in from when some of these cases previously aired. Also, chapters will be added for your convenience. Now, the first judge's courtroom we're going to be in is Judge Kristen Simmons out of the state of Michigan. And I haven't gotten a chance to say anything about this or really check this out. So I'm going to hang around a little bit on this first proceeding. And shout out to Sovereign Citizen Chronicles for sharing this with me. Second, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan also. And last but not least, we will be in the courtroom of Judge Tim Lewis. Listen, 192, we are on our way to 200. Keep liking, sharing, and subscribing, commenting. All of it is helping us get these videos out there, especially being that we haven't been doing videos every day. It definitely is helping us with the algorithm. Now, guys, it is about that time to jump into 192. Man, I am glad that I stuck around for this one. Listen, if you know anything about Judge Kristen Simmons, she does not play any games, and she went wild on Mr. Latney. And I think it's because a lot of these judges are just tired of hearing the sovereign citizen lingo, and some of them, you know, they're a little nicer than others, or I won't even say nice because I don't think she was being mean to him. I honestly just think she was being firm and just straight to the point. I'm not going to play those games, and this isn't the first time we've seen Judge Simmons go off like this. I remember one time a sovereign citizen was in her courtroom, and she said, "Listen, you better be careful with saying, you know, the things that you're saying about not being from this country and so on and so forth, because of a lot of the things that's going on in the country where people will come and pick you up if you are not from this country or you are not supposed to be here." So I've seen her definitely let these sovereign citizens know, like, listen, this is not the place to be playing games, and you better be careful how you playing games. But yeah, I just wanted to chime in on that. He owes about 10 grand. I mean, nobody's trying to hear the nonsense. You got to be accountable for your actions. You stayed in the man's apartment, pay what you owe. Now let's go ahead and jump back into 192.
This is E3 Investments LLC versus Zachariah Latney, 26-01434. Appearance, please.
Attorney Catherine Gable, P81555 on behalf of the plaintiff.
Your name, sir?
I believe the caption is Zach Latney.
It says Zachariah.
Zach Latney.
Okay, your name's not Zachariah?
I mean, as it appears on the lease, it's Zach Latney.
No, I don't know. I'm asking if what was filed is correct.
Yeah, Zachariah.
Okay, yeah. Thank you. And you don't have an attorney representing you, correct? Okay. Okay. You have not been able to come to resolution. This is for non-payment of rent?
No, Your Honor, we have not. I tried to speak with Mr. Whitney earlier, but we have no resolution.
Mr. Latney, you believe that you have a lawful reason to withhold the rent?
Yes, Your Honor. The equitable defense is cited in the answer, which should be on file with the court, Your Honor, which can be elaborated upon today.
Okay, you can have a seat. You can call your witness.
Thanks, Your Honor. Plaintiff's call Eric Romano to the stand.
Oh, if you can get their exhibits out of your way.
May I approach?
Yep, thank you.
Okay.
You can raise your right hand, sir. Do you solemnly swear or affirm testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. State your first and last name within spell both.
Eric Romano, ERICROMANO.
You can proceed now.
Thank you, Your Honor. Mr. Romano, are you the owner of E3 Investments?
I am.
All right, and Mr. Romano, does E3 Investments own the property located at 1130 West Mount Hope in Lansing, Michigan?
Yes.
Okay, and what is your role at E3 Investments, Mr. Romano?
I'm the owner, president. It's me, just me.
And on September 22nd, 2023, did you enter into on behalf of E3 Investments enter into a monthly rental agreement with Mr. Latney?
Yes.
Okay, may I approach?
Right.
Mr. Romano, I have placed in front of you what is entitled monthly rental agreement. Is that correct?
Yes.
Okay, and is that the lease that you executed with Mr. Latney?
Yes, it is.
Okay, and can you please tell me when the lease began and when it ended?
September 22nd, 2023, and it's a month-to-month lease
And when does the term of the lease begin each month, Mr. Romano?
on the 25th.
And when does the term of the lease end each month, Mr. Romano?
On the 24th of the next month.
Thank you. How much rent is due per term?
$1,100.
Okay, and does the lease call for late fees if rent's not paid within 7 days?
Yes, it does.
What is the late fee amount?
$50.
Okay, Mr. Romano, has Mr. Latney paid rent for the term August 25 through September 24?
No,
Has Mr. Latney paid rent
August 25 through September.
August 25th through September 24th? Sorry, it's a 30,
Okay.
okay, the answer is
I
no.
think I knew what you were saying, but was you thinking years at least?
yeah,
Got it. I think it's, got it.
okay.
I'll
I think he's
clarify.
thinking you're talking about 23, you're talking about the term. I know what you were saying, though. You can continue.
I apologize. So Mr. Latney did not pay rent from August 25th, 2025 through September 24, 2025, correct?
Correct.
And has he paid rent for the term beginning September 25th, 2025 through October 24th, 2025?
No, he has not.
Okay. And has he paid rent for the term beginning October 25th, 2025 through November 24th, 2025?
No, he has not.
Has he paid rent for the term beginning November 25th, 2025 through December 24, 2025?
No, he has not.
Has he paid rent for the term beginning December 25, 2025 through January 24, 2026?
No, he has not.
Has he paid rent for the term beginning January 25, 2026 through February 24, 2026?
No, he has not.
And has he paid rent for the term beginning February 25, 2026 through March 24, 2026?
No, he has not.
Okay. And has he paid rent for the term beginning March 25, 2026 and ending April 24, 2026?
No, he has not.
Okay. Mr. Romano, have you kept the premises in good habitable condition
Yes,
and good repair?
yes.
May I approach?
Man,
Mr. Romano, what I placed in front of you is entitled Payment Record. E3 Investments, v. Zechariah Laney. You recognize this document?
Yes,
And Mr. Romano, can you explain to the court what this document is?
it's a ledger, a payment record showing rents due and late fees approved.
Mr. Romano, what is the balance for rents and late fees due today?
$9,200.
And is that payment record a true and accurate reflection of what is due and owing under the lease with Mr. Latney?
Yes,
Objection,
what's the objection to?
just not receiving this, and that amount is not encompassing the original complaint.
You said not receiving the ledger?
Yeah, I'm just not receiving this. Is this being submitted?
I don't know. She's not,
I'm going to move to admit it as
Okay.
exhibit 2.
okay.
Okay, the amounts asked upon are inconsequential because they don't encompass that which is encompassing the original complaint.
You're saying that it's larger than the complaint?
Yes, ma'am.
You do understand that as the time progresses, the amount increases, correct?
So you're saying that
Yeah, like, for example, if I
No, I
continue,
understand the court's
if I
question.
continue this until next month, May 1st, the amount's gonna grow.
Precisely, okay, so the question then becomes, to what extent do those amounts? So essentially, that which is originally
Your
complained upon,
objection to the exhibit.
The exhibit said he never received it,
yeah, I never received it.
and that he says that
I'm
he
just not
thinks the
receiving
amounts
notices.
are,
That is a clear objection I'm having.
the amounts are off.
Yeah,
I'm gonna respond and say that's not an objection. It's an exhibit that's going to be admitted, and if he wants to ask questions about it, he can do that when it's his turn.
Okay, it's a copy of a ledger that you keep in the regular course of your business?
Yes,
Okay, objections overruled, it's admitted.
And I'm sorry, I guess I need to retract. I would move to admit the lease as exhibit 1.
And it's admitted.
Thank you. All right, Mr. Romano, again, I'm sorry, just for clarification, how much is owed for rent and late fees as of today?
$9,200.
Okay, and Mr. Romano, does that ledger include any court costs in that $9,200?
No,
Okay. And as to court costs, Mr. Romano, is it correct that you would be seeking those costs in the judgment today?
yes.
Okay, and no further questions, Your Honor?
Do you have any questions for the?
yes, Your Honor, I do.
Mhm, proceed.
Just allow me a brief second.
Okay.
Can I get my questions together? Is that an issue?
No, I just told you you can
Oh, no,
cross
it
examine the
seemed like
witness.
she had a complaint. I'm just like, what's the issue? All right, okay. Oh, what date did, okay, this is gonna be my question. What date did you allegedly engage in the lease with the plaintiff, Mr. Romano?
He
I mean,
is
with
the plaintiff.
With the defendant, Mr. Romano? Excuse me.
Jack, that's asked and answered, but go ahead.
He has answered that already.
The 22nd of September, 2023.
Okay, these proceedings, on what date did your attorney file the complaint initiating these proceedings?
That I don't know. I can refer that question to my attorney.
So I can take judicial notice of when it was filed. I have it.
During the court?
It was filed with the court, it looks like on February 20th, 2026.
Okay, February 20th, 2026?
Correct.
Okay.
Actually, February 23rd is the stamp on the side, which it was dated by the attorney, February 20th, 2026.
This action was filed?
That's when the complaint was filed.
Thank you, Your Honor. I do have more questions on point and which are relevant. Okay, I wonder for the record, is your phone number, Mr. Romano?
But you don't have to put it on the record, his phone number. You can ask the last 4 digits if you want to confirm
Thank you, I
them.
appreciate it. Does the last 4 digits of your phone number end in 9908?
Yes,
And did you text the defendant regularly for means of communication by way of payment to be received from you, from the tenant?
yes,
So you and the tenant regularly texted with that phone number ending in 9908?
yes,
Okay. Prior to initiating this suit, did the tenant text you respecting amounts owed and that were paid to you?
I'm sorry, can you repeat your question?
Prior to your attorney initiating this suit, prior to counsel initiating this suit, did you and the defendant communicate regularly by way of that phone number ending in 9908?
yes.
Thank you. Okay. No last question. A few more questions, Your Honor.
Take your turn.
Thank you. Do you recall communication taking place between you and the defendant on or about March 4th of this year, 2026?
No, I don't.
You don't recall?
I don't recall it.
Okay, so you don't recall a text message taking place between you and the defendant wherein the defendant gave you formal notice by way of text message?
Objection asked and answered. He said he doesn't recall the messages.
Okay, no problem.
Objection sustained.
Quick question for you. Are you aware of any text message that took place between you and the defendant on March 15th, 2026 of this year? Is it your response to this question that it?
He said no.
No. Okay,
Oh, okay.
follow up, please.
Yeah.
Okay. You're not aware of any communication that took place. Since you're not aware, this is my question, since you're not aware of any communication which took place on March 15, 2026 between you and the defendant, there will be no cell phone records wherein confirming you received the same?
Are you asking me, are there cell phone records? Because he's saying he's not aware. He's not saying it didn't happen. He's just saying he's not aware.
He's not aware, okay. My question is that because he's saying he's not aware, then there would not be any cell phone records affirming that he's actually read the messages which he claims he's not aware of.
Are you saying that no conversation took place, or you just don't remember?
I'm saying I don't remember.
Yeah, so he's not disputing that there was text messages,
Okay.
he just doesn't remember.
Are you aware that on March 15th, 2026, you were expressly appointed as trustee privately by the defendant?
I'm not aware.
Okay, you're not aware of that. That's fine. Just give me a second. See if I can get anything more relevant for the witness, and I'm gonna let him go. Okay. Oh, yes, this is actually very poignant. Prior to you and the defendant engaging in a lease, did you require any criminal or background check for the defendant to engage in? And was there any documentation that you took to that effect?
Do I
Objection,
require?
compound, and form.
Compound meaning you asked two questions in one, so you break it up.
Sure, no problem. So I can like.
You can rephrase it, but only ask one question at a time.
No problem. Prior to engaging in the lease, which is subject to this underlying suit, did you and the defendant engage in a creditor background check?
I don't remember.
Is it your testimony today that you never required a social security number to be provided by the tenant?
I don't remember. That was 2.5 years ago.
Okay, so with text messages,
I'm gonna object as to
He doesn't
relevance.
remember, so you're gonna have an opportunity to give testimony. If you want to share any of that, you can do that.
No problem.
You don't gotta get him to get it out of.
No, that's,
Yeah.
I'm just,
He said he doesn't remember, so he's
I
not
gotta
disputing
lay a
it.
foundation though. At some point.
No, you don't. If you wanna tell me all that during your testimony, we'll allow.
I don't
you to
know if he
tell-
doesn't remember unless I ask, Your Honor.
I get it, but him remembering or not, it really has nothing to do with whatever point you're trying to make with that.
Well, if he said he remembered, it would actually affirm the point I'm making, is what I'm getting at.
Okay, well, he said he doesn't remember,
Okay, no problem.
and you're trying to re-ask him in another way. He's not gonna change his
No
question
problem. Okay,
or his answer.
that's the witness, Your Honor. I'm done.
You can redirect if necessary.
Your Honor, redirect is not necessary. Thank you.
Any other witnesses?
No, Your Honor.
Thank you. You want to get testimony, sir?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, I do, Your Honor.
Thank you. Tell me why you believe you don't lawfully owe rent since September of 2025. I'm sorry, August of 25, or is it? Well, I guess it's September 25th of 2025. You haven't, the testimony was you have not paid rent since September 25th of 2025.
Yes, Your Honor.
So tell me why you lawfully can withhold rent, or why you believe that.
Well, first and foremost, I would direct the court's attention to the answer, which is on file.
You have to tell me
But
your
there's-
reason. I've read your answer, but that's not evidence.
Okay, no problem. I'll give you, okay, so on March 15th, let me give you the whole layout, since I'm on the record and I can get it all out, right? Let me get it all out, and I'm gonna testify. I'm giving my testimony right now. So prior to engaging in this lease with Mr. Romano, he required, and I have text messages to that effect, which he's received, he's read, but it's okay. I have text messages to that effect between me and him, wherein prior to engaging in this lease, he specifically required a social security number.
Okay.
And in requiring said social security number, it was for the purpose of a credit or background check. Said social security number was reflective of the principal obliger on the lease. This is antecedent to the lease that is signed and in the record and encompassed in her complaint. Okay, said social security number that was taken from him is not reflective of myself. It's not reflective of myself with respect to being obligated regarding this. This is just a primary claim that I'm making. I have a secondary claim, which is an equitable defense, which is layered onto this. Just bear with me, I'm not in court.
I'm listening.
Thank you, I appreciate it. He was noticed of suretyship and subrogation rights with respect to the social security number taken and reflective of the principal obliger on the lease. He was noticed of a legal distinction being made with respect to the principal obliger and myself, as a matter of fact, by way of documentation provided to him in these text messages. Not
Are
only,
you saying that was the nature of the text messages you sent in March?
yes, Your Honor, I am. That's precisely what I'm saying.
Okay.
Actually, these text messages go back to February. Secondarily, with respect to the suretyship and subrogation claims, to which I stand as subrogate to the principal obliger underneath the lease, to whom I stand as subrogate with respect to the principal obliger on the lease. Him being a creditor or the subrogor, he was noticed that my suretyship and subrogation rights were transferred to him in trust for my sole benefit. What I am saying is, prior to even showing up to that first hearing 2 weeks ago, he was noticed of and read text messages wherein he was expressly appointed as a trustee and owes me fiduciary duties as sole beneficiary prior to initiating this suit. That is my purely equitable defense that I'm asserting here today.
Okay.
As a result thereof, and as a result of those allegations of fact, which bear on this immediate case, Mr. Romano and E3 Investments LLC, by way of a trust indenture, which I can show this court and my phone number, stands with respect to me as my trustee. And he owes me a duty of undivided loyalty as my trustee, as is my allegation of fact today. And I am the sole beneficiary with respect to that trust that I can provide the court. He owes me fiduciary duties and a duty to account with respect to that which he was entrusted with, specifically and prior to engaging in these proceedings. And he was noticed of that. Not only that, but as sole beneficiary, equity regards me as the true owner. And my sole defense right here and now is that he stands in relation to me as a trustee and a fiduciary, owing me duties sacred in equity, to which I can't freely enforce in probate court. And as this court has been made aware of, this court doesn't have jurisdiction over those exclusively equitable claims of beneficiary of trust relations. But that is my equitable defense that I'm asserting here today, that he was granted a fund in trust, that he possesses said fund, and that as fiduciary, he owes me a duty to account as sole beneficiary. And that said accounting that he owes me directly conflicts with the legal relations that he has as landlord in this underlying suit. And I am now asserting there is a conflict and variance between the rules of equity and the rules of law with respect to the same matter. And that owing me an exclusively equitable duty of trusteeship.
That said he owes you a duty of trusteeship?
Yes, he does.
Okay. Any other argument for why you think you can live in his property for free?
He's been granted the fund to which he must account. These are equitable rights.
You granted him some funds?
Yes, I granted him the
Where?
fund. By the way, I'll show you right here. Got you right here, Your Honor. Got you right
Show
here.
his attorney where the funds were sent to her client.
Are you, is the court saying as a matter of fact that he's not?
Show me where you're gonna show me evidence where you sent him the funds?
Yes.
Show it to the attorney first,
Thank
where
you.
he was sent his funds.
Got you right here. Got you right here. Give me 1 second. I'm just pulling up the text. You're gonna see it says red right next to it too.
For clarity, Your Honor, if I may, this is rent payments for the
Correct.
monies we're claiming due and owing,
Those are the only funds
Not-
I'm looking about.
not previous.
So,
correct? Okay,
Is
just
this
for
court
clarification.
asserting that I do not have that equitable defense asserted is not
I don't-
relevant?
Well, let me be very clear here. I read your answer and I gave you ample opportunity to make a record here. I don't really know if there is an underlying issue that requires a competency evaluation, or if you Googled something that made you think that these things were lawful reasons to live in someone's property and withhold rent. You speak over me, you will be remanded for contempt in court. I don't know what's going on, but none of the things that you say or have said in this courtroom as it relates to a lawful reason to withhold someone's rent makes any sense. For you to sit here and vehemently assert that the landlord, after telling you that you are filing a notice to quit and vacate his property for failure to pay rent, now owes you some duty other than to collect the rent from you, sounds bat crazy. Bat crazy. You don't live in someone's house for free. You show me where you paid the rent or that you have a lawful reason, not some cockamamie story you didn't came up with. Your answer looked like you cut and pasted something from a probate court proceeding from probably a sovereign citizen, crossed out what you didn't think applied and signed your name to it. We don't run circuses in here. This is a courtroom of law. You understand me?
May I respond, Your Honor?
If you have proof where you paid rent, show it to her. Otherwise, judgment for the plaintiff.
Your Honor, may I respond?
Do you have proof?
I'm trying.
Do you have proof?
You asked me to do two things.
Well, I ask you one thing.
Court to be-
Ask you one thing. Do you have proof?
Yes, I do.
Show her the proof.
Got you right here. I was in the middle of getting that earlier, but
No,
I
that,
didn't want to interrupt the court.
listen here, show her the proof, because she wanted to clarify what you were about to show her.
Okay.
I don't wanna see no text messages of no, I notified him of some trust. That don't work here. We're not dealing with trust, we're not dealing with probate, we're dealing with possession of property. You signed a lease.
I know I'm at law.
You signed a lease. You agreed to pay the money. I don't care if he did a background check or if he didn't.
Well,
I don't care if you gave him your social security number or if you gave him your telephone number. You agreed to pay this rent. You've been holding over his property since August of 2025. And I want to see proof that you either have a lawful reason to withhold it or proof that you turned it over and he's just mistaken.
Okay. Thank you. Thank you. My mandamus gonna go in tomorrow too. Don't worry.
You can find a mandamus or anything else you want to file. I really do not. I promise you, I don't care.
That's okay. So it's a quite lengthy text. That's why I'm trying to find it. But I'm gonna show
Is
you
this
right here.
evidence of you sending his past due rent?
Yes, he's in possession.
Okay.
He's in
You
possession of it.
You
Yes,
can show the attorney for her review.
yes, 100%. And I'm standing on my equitable offense regardless. What are you reading right there?
It says declaration of trust and appointment of trustee. There's no
Judgment in favor of the
Thank you,
plaintiff.
Oh,
You can be
wait.
excused. Bye, bye.
Yeah, I know. My mandamus going in too.
File whatever you want.
Yeah, yep.
You have paperwork.
I do, Your Honor. Is it
Don't worry.
the possession 427?
The writ date
Yes.
is the 27th.
Thank
That
you.
is correct.
Your Honor, do you need to prorate on the record or amounts due for the money
Yes, please.
judgment? Okay, for possession, Your Honor, he owes $8,800 in rent, plus $400 in late fees, plus costs in the amount of $174.80, for a total of $9,374.87. And for the money judgment, Your Honor, which has been prorated through today at $36.67 a day. Rent plus late fees is $8,870.07 with costs of $174.87. Sorry, yeah, it's $174.87 for a total of $9,044.94 for the money judgment.
Thank you.
You're welcome.
Any additional matters for the record?
No, Your Honor.
I think I've earned a recess of 5 minutes.
This is the city of Detroit. These are the cases that make me famous. Versus Bernard Brandon Little, case number SP 1695294, counts 1, 2, and 3. SP 1695296, counts 1 and counts 2. Here to the record, please.
Oh, that's very.
I don't know if you represent Mr. Little. Good morning to you. State your name for the record, please. You have to unmute yourself, sir.
Hello? Can you hear me?
There, you got it. You got it.
Okay.
State your name. State your name for the record, please. You keep breaking up. I think you just muted yourself again. I got pressed unmute.
Hello?
Okay, go ahead.
Bernard Little, making a special appearance.
Everybody's making a special appearance, aren't we? All right, what are we gonna do with these cases, sir? See where we're at. What are we gonna do with these cases?
I would like to resolve these cases, Your Honor.
right.
Is the officer here?
Let me do this one of two ways. You either take a plea or set a trial date.
I'm not
What do
going
you want?
to take
Or,
away.
or,
I would like to ask for dismissal on the grounds of jurisdiction. Also, hello, can you hear me?
I can hear you.
I would also like to know if the officer is here.
Today's date time set for a pretrial. Officer doesn't have to be
Yep.
here on the date of trial. That would be time for the officer to come in. Let me make sure it's pretrial. Pretrial, yeah. If you want to set a trial date, the officer would have to be here at that time. I'm going to deny your motion that you just made on the grounds that you made on the grounds of jurisdiction. I'm going to deny that motion. All right. So I want to set a.
Can you make it a matter of records that I request that they approve
Made it a
jurisdiction?
matter.
You skilled me?
I made it a matter. You made a record of it. You made the motion. I made this on the record.
Okay, thank you, sir.
Okay, so I'm going to set a jury trial date.
Yes, sir.
Can I get a jury trial date? Let me see. Did you come down here before for a jury trial date in person?
Yes. Yes.
And on that date, your cases got dismissed, didn't they?
Yes.
And you indicated something that time that you just want to pay something. Is that right, Mr. Little, I'm thinking about?
You probably are correct.
And in all these years, you had a valid driver's license. And then all of a sudden, that's when we talked about, I said, you just woke up one morning and said, all of this stuff is a sham, and I don't believe in it, right?
No, it's a process. We work.
That's what we talked about when we dismissed the cases the last time, right?
Yes.
I just wanted to know if my memory served me correctly. So
Jury trial is June 24th.
June 24th, jury trial. How many dates? Let's see what we have scheduled for June 24th. I don't think that's a good date.
Oh, there's 11.
Yeah. So we don't have June. We have to push it back.
Okay, let's see. On July 8th.
I think it's 2 on July 8th. You know how this works, Mr. Little. I'm going to set a jury trial date, and the day before that jury trial date, I'm going to set a final pretrial date. On that date, the officer must appear on the final pretrial date to make sure that we're not calling the jury in and inconveniences the great citizens of the city of Detroit and bringing them in without with knowing that the officer's not here. What is that on?
July 8th, there's no juries scheduled for that day. And that's your next.
All right, let's make it July 8th, Mr. Little. July 8th, 2025 at 9 a.m. The day before July the 8th will be July the 7th. We're gonna call that a final pretrial 2025. So the next date I need you to appear is July the 7th, 2025 at 8:30, and expecting to have a trial in person on July the 8th. You don't have to come in person for the pretrial, but you do have to come in person for the trial if it goes. We'll know that on July the, and all parties must appear for the final pretrial. Okay, Mr. Little,
Yes.
any other records you want to make, sir?
What do I want to say? I just want to make a matter of record. I'm the free man. I'm not the.
I can see that. I can see that. You're not calling from a prison yard.
No. No,
Okay,
not at all.
All right.
Okay.
Is that
And I
all?
also like to make a matter of record. I like to make a matter of
All
record
this
too.
is your TV, by the way. Go ahead.
Well, it's being recorded on both ends, your end and my end. So, also like to make a matter of records. I would like to know if the bonds is in court today.
The what?
The bond, the surety bonds that's created for this case.
You have a $0 bond.
No, the surety bonds that's sitting on your desk. When you flip open the file, are they sitting on your desk today? I want to make a matter of record that they are in court.
I have no clue what you're talking about. If there's nothing further, Mr. Little, have a very good day and best of luck to you, okay?
Mm-hmm. You as well.
All right, thank you. Mr. Little, what do you want to do? Trial or take the deal?
What I want to do, I want to get it dismissed.
It's not gonna happen like that. You know it's not gonna happen like that. You
But that's
gotta
okay
dismiss
too.
last time.
I would like to make it a matter of record, because I want to prove that the court does not have the jurisdiction to even prosecute.
All right, I'm gonna get the reviews out.
Okay,
and then
I
I'm
think
gonna
it's been
call.
fraud.
All right, hold that, I'll just make a record.
Point all this stuff out.
I'm gonna get the reviews out and then I'm
Yes,
gonna let,
Yes,
you
sir.
make your record and we'll get you on.
I also like to see those bonds today too, sir.
I don't know what you're talking
You
about.
know, they sitting on your desk, they sitting on her desk. No file over there.
All right,
Take a bond every time the person comes to court. Financial has nothing to do with court.
all right, City of Detroit, Mr. Lahari, now, I'm gonna give you a chance now. Let's not keep going back and forth. Wait till your turn gets ready. City of Detroit. Versus Brandon, let's start that, Bernard, Brandon Little, case numbers SP 1695294, counts 1, 2, and 3, SP 1695296, counts 1 and counts 2. Mr. Little, good morning to you. State your name for the record, please.
Grand Rising. First of all, Your Honor, I'm your magistrate. I would like to know, do you recognize that a man stand before you?
Stand up, stand up to the
I'm at
podium.
the podium right here.
No, stand up to the podium.
Your Honor.
All right, no, we're not gonna do this your way.
I'm at your podium because under duress, I'm standing at your
We're
podium.
gonna do this my way.
Yes, sir. We are
All
gonna
right.
do it your way.
All right, state your name for the record again, please.
For matter of record, Your Honor, do you recognize that a man standing before you?
I do.
All right. For the record, my name is Bernard Brandon Little. Not the fictional, not the all caps, but the man.
Okay, now, indicated you wanted to make a record, I was allowing you to make that record. You indicated some things in the record.
I indicated on the record that you stated that I was a man. A live man, not fictional.
No, we off the record when you were.
No, we're on the record,
Listen,
Your
listen.
Honor. Did you recognize that a man standing before you? Your Honor,
Listen, sir.
your magistrate.
Mr. Little.
I'm asking you.
Mr. Little,
Yes.
you don't ask the questions, I ask the questions.
No, you don't, Your Honor. No, you don't.
All right.
You're a magistrate.
All right, listen.
You don't have the authority. You
That's
don't
it.
have the authority, Your Honor. You're a
Listen,
magistrate.
listen,
You don't
sir,
have the
I'm not gonna
authority.
keep going back and forth with
You're
you.
not going back and forth with me.
Put him out. And I don't need your comment either. Whoever made the comment. All right,
So
get out.
you're refusing me?
Get out.
You're refusing me, Your Honor?
Get them out.
I need to exit, sir.
Yes, ma'am. No problem.
Have a good day. No problem. I got you.
Okay. Okay.
Have a good day, Mr. Love.
Yeah, got it.
While court is in session, everybody needs to have their device on vibrate or silent.
Well, guys, we have come to the end of Mr. Little's pretrial proceeding, and whoa, Judge Perkins was not trying to hear anything today at all. He definitely had a short fuse today. And if you know anything about these two history, they've had some back and forth, but if you go through his previous proceedings before Judge Perkins actually has really been, real cool with Brandon Little. There's times when it seems like he kind of likes him a little bit, even agree with some of the things he said in some of his past proceedings, not so much on sovereign citizen stuff, but on some other things. But to see him have such a short fuse today with him, I guess he came to work and said, listen, I'm not trying to hear anything. I'm not trying to play any games. And as we can see, Mr. Little was put out of the courthouse. And tomorrow was supposed to be his trial, depending on what happened today. But I went into the court records to see what they decided to do. It's been removed from the calendar. And they also put into the record that defendant failed to appear today. So they put it in as a failure to appear, even though he was there, had the argument. They're not playing any games. So with that being said, we will continue to follow this. Who knows when his next court date is going to be. I'm sure, we'll find that out soon. But wow, Judge Perkins definitely went in today. Unfortunately for Mr. Little, but if you know anything about Bernard Little, he knows what he's doing. And if you haven't seen his previous proceedings, I will put those links down in the description so you guys can check those out. But with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. Thank you guys. See you guys soon, and God bless.
And sir, in the Nisqually jail, what is your name, please?
Raymond Charles Lafferty, Lafferty. How are you this morning and how's the court?
Thank you, sir. And your date of birth is July 2nd, 1969?
That is correct.
Your Honor, before we go any further, I hate to interrupt. I am just going to need a couple of minutes in a breakout room with Mr. Lafferty.
Oh, sure. Okay, so Mr. Lafferty, there on the screen in front of you, you should receive a invitation to join a breakout room. Please click join. If there's no mouse in there for the computer, you'll have to ask the officer to assist you. But we're going to put you in a breakout room so that you can speak privately with your attorney before proceeding with your hearing, okay?
All righty then.
And you may need, if you don't see it on the screen, you may have to ask the officer to assist you.
It's not, like it says Lakewood Community Court inviting you to join room. Join.
Join, yeah.
Nothing on my end.
Okay, you can go ahead and ask the officer to assist you. The officer can help you go and get into the breakout room.
You need your assistant.
All right, so Mr. Lafferty, just hang tight, and then I'll call your case as soon as the court is ready, okay?
All righty.
And your last name was what's it?
Lafferty, Laff.
Okay, I got you. Thank you, sir.
Mr. Reardon, did you have an opportunity to speak with Mr. Lafferty in private?
I did, Your Honor, and we are prepared to go forward with the arraignment. Thank you.
Thank you. Sir, you are before the court for arraignment one charge of criminal trespass in the second degree is charged by the city of Lakewood and it would be a criminal complaint 25L004378. Mr. Reardon, how would you like to proceed with the arraignment?
Thank you, Your Honor. I did have a chance to talk to Mr. Lafferty about this charge and his rights at arraignment. I want to enter a plea of not guilty on his behalf. Also, I do believe he qualifies for the public defender, Your Honor. I'm asking for direct appointment to the public defender's office without a promissory note. Thank you, Your Honor.
Thank you. Mr. Lafferty, the court is going to find that there is probable cause to support the filing of the charge. We'll enter
I find that there isn't.
I will enter.
I may or may not be an arbiter of the law, having attended UC Davis and completed but not received my certificate.
Mr.
That officer proceeded with me was not respectful or within the 24-hour period that had been stated. There
Mr.
are
Lafferty,
individuals in the park who took the pictures to make sure that it was unclear. Again, I had been made homeless by 2 officers from my nephew's house just
Mr. Lafferty, I would encourage you not to say anything just for now. The prosecutor is going to talk in just a moment, and then I will talk to you about.
As an indigenous person from California, I'm not sure you have any jurisdiction over me, and I wish that my tribal chairman, Curtis Lachusa from Mesa Grande, was informed that we have our own law and we have our own lawyers.
Mr. Lafferty, like I talked about, we can talk about your case, but let's go forward with this for now, and any questions you have going forward, we can talk about it after your hearing, okay?
Fine.
Court is going to enter a plea of not guilty for Mr. Lafferty at this time and is going to waive formal reading of the criminal complaint. Mr. Taninga, what is the prosecution's position concerning pretrial conditions of release?
The city has no objection to the defendant's release on personal recognizance under the conditions the defendant have no contact with Kiwanis Park and the defendant have no criminal law violations during the pendency of this case.
So then you're going to remand me over to being homeless in the state of Washington.
No objection to release on personal recognizance, Your Honor. I believe that's appropriate. Thank you.
Thank you. Court is going to follow the agreed recommendation of the attorneys. The court will release Mr. Lafferty on his personal recognizance. So Mr. Lafferty should be released later on this afternoon.
To be homeless as an indigenous senior citizen.
Court is going to impose a number of pretrial conditions.
I do not recognize those. Then I guess I won't be leaving jail.
Mr. Lafferty, please just hang tight.
Mr. Lafferty needs to appear in person and on time for all scheduled court hearings. His next hearing in this matter will be on August 12th, 2025 at 1 p.m. here at the Lakewood Municipal Court. The court is going to appoint Mr. Reardon to represent Mr. Lafferty.
I do not want Mr. Reardon. I want a tribal representative in charge of me.
Well, and Mr. Lafferty, if you choose to hire a different attorney, that is your prerogative.
That would be up to my tribal chairman and our legal defense team.
But at this point, the court is going to appoint Mr. Reardon.
I do not accept the appointment then.
And the court is also going to order that Mr. Lafferty have no criminal law violations, that he update the court of any change in his mailing address, that he have no contact with the Kiwanis Park in the city of Lakewood while this matter is pending. And the court has signed that order.
To be homeless. I'll just stay in
Mr.
jail.
Lafferty should be released later on today.
I refuse to be
Lafferty,
released.
thank you. That will conclude your hearing. You can let the officer know that your hearing is done. Thank you.
Competent fool.
I'm not threatening you. Say one more word and that's 30 days. 30 days.